Good morning, and thank you to everyone for joining us today for another chapter in our ongoing series entitled Do You Know What Your Neighbor is Doing? In these series, we attempt to unpack emerging legal issues that are impacting both clients operating in Canada and the United States. My name is Peter Stockburger. I'm the office managing partner for the firm's San Diego office, and I'm a data privacy, cybersecurity, and AI attorney, so I'm not busy at all these days. My practice really does focus on cross-border clients, and I will be your speaker and moderator for the session today as we unpack emerging risks in the digital ecosystem impacting businesses both operating in the US and Canada. And when we talk about emerging risks in the digital ecosystem, there are a lot to discuss, and we could probably spend a whole day talking about these risks. But today we're going to focus on a few particular risks, and that really is around the litigation risk in the US and Canada around privacy issues. And we're going to be talking about website tracking cases, chatbots, session replay, ADA accessibility, and I know Chloe has got a lot of other issues in Canada that are percolating. And then we're also going to be looking ahead at an emerging area of risk around artificial intelligence and the litigation landscape and regulatory landscape that folks are facing in both Canada and the US. So we hope it's going to be an engaging discussion. With me today are some expert speakers on the topics. We have Chloe Snider, who's a partner from our Toronto office, who's a whiz on all things privacy class actions. I believe just before she joined the webinar, she was navigating and resolving some privacy disputes. So looking forward to her insights. And joining Chloe from Canada is Kelly Osaka, a partner out of our Calgary office. And Kelly's going to be diving into the wild world of AI these days out of Canada. So with that, Chloe, I actually want to turn it to you first to start north of us, up in Toronto and Canada, to kick off the discussion around trends in privacy class actions and what you're seeing from a litigation side, from a privacy side in Canada.
Thanks, Peter, and thanks everyone for joining. I'm happy to be speaking on trends in privacy class actions in Canada, and there are really 5 themes or trends that I'd like to cover today. The first is trends in certification. I think it will come as happy news to many people on the call that I think there's been a bit of a recent chill on the certification of privacy class actions in Canada. The second theme is settlements of privacy class actions. And again, I think it will be a relief to many of our attendees today that we've seen many privacy class actions now settling for very low dollar values per capita. And then the third issue is merits hearings, because Canada, I think it tends to be a little bit behind whatever is going on in the US litigation landscape. We have only started to see merits hearings in privacy class actions. And so I want to deal with that and vicarious liability issues that have arisen in that context, and then finally what the future may hold. So just starting then with the themes and certification, what we've seen in the last year or so is really courts across Canada taking a closer look at the cases that are being put forward for certification to really test in, I would say, a more rigorous way than was previously being done, whether the cases are ripe for certification. And in particular, one of the causes of action that is generally used for privacy class actions in Canada is the privacy tort intrusion upon seclusion. And that has as one of its elements an intentionality. And so previously, the Canadian courts were saying it was sufficient to satisfy that intentionality requirement or the recklessness requirement of an intrusion upon seclusion if a big company had been unable to protect private information or personal information from a third-party hacker. And those cases were being certified. And what we've seen in the last year is courts saying that we call them generally database defendant, a defendant whose database has been hacked by a third party, that the intentionality and requirement of the intrusion upon seclusion tort isn't met where you have a defendant that's been hacked. Maybe there's been negligence, but there's been no intentionality or recklessness, because at least in Canada, recklessness is a form of intentionality or intention. And so there have been a series of cases that have now been denied certification on the basis that a database defendant cannot be liable for the privacy tort because even negligence wouldn't satisfy the intentionality requirement. And so those cases have been denied certification on the tort-based, the intrusion upon seclusion tort-based claims, although have been allowed in some cases to proceed on negligence claims. But I think this development is still important because in negligence, you have to prove some sort of compensable harm. Whereas for the privacy tort, you could be awarded moral damages. And so even if you have moral damages of $100, $500, something small per class member, if you have a class of 500,000, that number easily gets to be very big. But if you have to establish compensable harm through negligence, I think that becomes a lot harder, except in the rarer cases where there's been some sort of identity theft or fraud that's occurred as a result of certain types of personal information getting out there. So that's one of the themes that we've seen from a certification perspective. And then we've seen other courts as well on the certification front really take a closer look at the types of privacy breaches they're letting through. So there was a recent case where a nurse had accessed many patients' personal information for the purpose of this nurse herself getting those patients' drugs. And the Ontario Divisional Court said, well, that wasn't really enough to give rise to anything that would be highly offensive, causing distress. It's clear that this nurse was after drugs. She wasn't really after the personal information. And so that case was not certified. So courts really taking a closer look. And that really plays into the second theme, which is settlements. And this theme actually dates back now a couple of years. Where we've seen that the settlements especially in either database defendants cases or cases of lost devices where an employee has a USB key or a laptop that's been lost with nothing intentional, but just someone has misplaced a device that had a lot of personal information on it, that these settlements are really have been really low value per capita. And in fact, one of our class action judges in Ontario, Justice Burrell, did an analysis when he was certifying certifying and approving the settlement in the Yahoo privacy class action that had been started in the United States and in Canada. Really doing an analysis of all of the prior settlements that he could access and finding that, some of it was really cents per capita. And so I think that has driven perhaps a bit of a cooling off in this area, but certainly if you have a large class, that can still result in a fairly large settlement. But the idea of some very high dollar value per capita as part of a settlement, I think has gone away, and that has perhaps caused the plaintiff class action bar to reconsider the financial incentives of class actions. I mean, certainly there's a role for the class counsel to play, but I don't think that's a controversial statement that there has to be a financial incentive. And I think from the way that the trend has gone in Canada, I'm not sure that they're seeing that financial incentive anymore. Because
I had a quick question on that from a US perspective.
Yeah.
So as a business operating in the US, we see there's a litigation threat in the US, both on using websites and cookies, and also on the data breach side and some of these intrusion on seclusion claims. Are you seeing the same trend in Canada? So if you're a US business doing business in Canada, is the plaintiffs bar, are they focused on data breach class actions? Is that what we're seeing on these settlement and certification issues, or are they expanding it into other areas of privacy claims?
Yeah. Yeah, that's a really good question. And I think with that, I'll jump ahead to my original point 5, which is sort of future looking trends. So I would say, to answer the first part of your question, that a lot of what we have seen have been data breach cases, a lot, or where there's been an employee who has either done something intentionally or has lost a device. Certainly there are a number of cases involving lost devices, less so with cookies, although I think the trend that we'll see is a greater focus on cases involving lack of consent, where companies are using personal information that they've obtained in a way that the plaintiff or class member says they didn't consent to, for advertising and for the company collecting the information to make money off of it. I think that that's probably what we're going to see more of, because in those cases, I think that the plaintiff will be able to establish the intentionality, and I think the courts will be more open to certifying those, and maybe there'll be some sort of greater damages claim, because especially if the defendant was able to make money off of this. So I think that that's probably what we're going to see based, Peter, on our discussion before this. I think that the class action bar is probably a bit more sophisticated and ahead in the United States, and that the class action bar here looks to what is happening south of the border, and whatever trends you're seeing, we see a little bit later. So right now, I think what we've seen a lot of the data breach cases, lost device cases, moving towards more lack of consent cases. And one of the decisions that we've seen on the merits out of BC was a case against Facebook for using personal information as part of these stories that were generating some ad revenue, and lack of consent. And so in that case, the British Columbia court found liability for Facebook having used people's images without their consent. And that case was bifurcated, so there was a liability trial. Liability was established, and I believe that the damages trial is ongoing now, or has just completed, and so that'll be one of the first tests of how to measure damages. So I think that the consent cases are probably going to be more prevalent. But I guess turning it back to you, where do you see the class action bar focusing?
Yeah, well, in the United States, we've really got a plethora of different options that the plaintiffs bar are targeting from a privacy standpoint. Historically, in the U.S., privacy litigation has been focused on data breach and post-data breach. So arguing that personal information was not properly secured, wasn't reasonably secured, and each of the 50 U.S. states have rules around maintaining reasonable security around data. So there was always a hook, always a negligence hook or a statutory hook post-data breach. What we've really seen an emerging risk on, and Nick and I will be talking about this, Chloe, next, is the plaintiffs bar has gotten creative in looking at old statutes in the US, especially here in California, looking at laws that were passed decades ago to address issues like electronic eavesdropping from the Nixon administration, and leveraging how those laws were written to apply to today's electronic communications and how people use the internet. So to your point, Chloe, we have a very creative plaintiffs bar, especially in California. Nick in particular is a whiz at dealing with all of the folks on the other side and where they're focusing their attention. But so Chloe, it's a little bit of, I think, of a tougher environment. But Chloe, one question I had for you from a Canadian perspective is that clients are often thinking about, I know from a US perspective, wondering, well, going into Canada, launching a website or an application into Canada in this digital ecosystem, is my risk really federal, or is my risk really provincial and local, for example, in Quebec or in British Columbia? Is that where the cases are being filed? Is that where I need to focus my attention on cookie disclaimers? Are you seeing that the privacy litigation risks in Canada apply across Canada, or are there particular parts of Canada where clients, should really focus their energy if they're looking to enter the market?
Yeah, I mean, so although our court system is provincially based, I mean, we do have a federal court, but their jurisdiction is quite limited in scope to IP, maritime law, like very, very narrow issues. So any type of privacy, consumer class action type case needs to be filed provincially, but each provincial court can certify a national class. So if you have users across Canada, the class would be a national class. And then in cases where claims are filed by different law firms in different provinces, they either enter into agreements, like consortium agreements, or there can be carriage fights, and then stay applications to try to deal with the overlapping nature of national classes for which certification is sought. So I would say that it is a national issue. My sense is that British Columbia is becoming more of a hotspot for class actions, just because of recent legislative changes in Ontario. But certainly I think wherever there's either in Ontario or British Columbia class action, there'll be a separate one in Quebec as well, typically. And so I do think that for American companies looking to do business in Canada, it would be a national class issue, although there are different pieces of legislation, like British Columbia has a Privacy Act that Ontario doesn't have. So in Ontario, the class counsel need to rely on tort-based law as opposed to statute. So there are differences across provinces, but I think the risk is still national, just given that the classes are usually nationally based.
Bottom line,
I thought what you were going to. Sorry.
I said, bottom line, if you're doing business, call Chloe and Kelly. That's the answer.
Yeah. I realize we're probably almost at time on our section, but I guess the last point I would just say on because the two other points I was going to get into were merits and consent, and we sort of got into that. But just on the merits side, one other case also out of British Columbia was a case dealing with vicarious liability, where it was an employee that had taken information and basically sold it to some very bad people, who then actually vandalized, committed physical harms to the class members' property. And the issue in that case was whether or not the employer was vicariously liable, and the BC courts found that there was vicarious liability. So although we're seeing that a database defendant may not be liable for what a third-party hacker does, I think employees are one of the biggest areas of risk for companies, and that great care needs to be taken on that end about employee training and limiting access to only employees who need access to personal information, whether it's personal information of clients or of employees. And so I think that's actually one of the bigger areas of risk is vicarious liability for employee misconduct, where an employee may have had access to information as part of their job and then misused it, even though, of course, that would be against the interests of the employer. But I think that's an area where the law is not very favorable from an employer's perspective, and so that's an area where I think we will see more case law and where care does need to be taken. So that was just the other trend that I wanted to speak to.
Yeah, it's I'd say insider threat for employers on the US side is equally and increasingly the number one threat folks face in data loss and data litigation. Chloe, looking south of the border now on the US side on the litigation trends, and Nick Pujji, my colleague just up the five in LA, and a whiz on all things digital ecosystem. Nick, I wanted to toss it to you to tee up the U.S. discussion, because on the U.S. side, we're going to break it down into different buckets because we have such a creative plaintiffs bar here. But Nick, I was hoping you could kick us off talking about website accessibility and video. I guess it's video closed captioning cases, which are continuing to be prevalent.
Sure. Well, thanks, Peter. And good morning, everybody, at least from the West Coast. Good afternoon on the East Coast. The thing that we see throughout the US, frankly, but particularly in California, given some of the laws that get issued, is a lot of opportunism. We are, in the US, we're famous for, heavy volumes of lawsuits and often frivolous lawsuits. There are firms that are designed to look for developing laws, half-baked laws, opportunities, as they would call it, to create some type of headache out of, a legal issue. And the digital accessibility landscape, unfortunately, has kind of suffered from that virus. And so, let's be clear, the ADA and other accommodations laws are good laws. They're designed to protect people and individuals with disabilities. The headache comes up in the sense of how they get enforced and how they get interpreted and so on and so forth, and arguably when people abuse those types of laws and protections. And so many of you may be familiar with the traditional ADA claims where someone says, hey, I have a wheelchair, but your ramp is not accessible, or you don't have enough parking spaces, or your counter height isn't at the required height. Those happen all the time. Unfortunately, even in that landscape, there are lawyers that, rather than someone actually suffering an issue or a violation or not being able to access a business, what happens is there's groups of law firms that just go door to door to door to door looking for issues, and then they put in the plaintiff and the claimant afterwards and bring claims that way. So that type of model has certainly started going digital. Probably about 7-8 years ago, there was some DOJ guidelines that said, yeah, a website can be, if a brick and mortar physical location can be a place of public accommodation, so can a website. And we saw that even more, of course, during the pandemic, where, shopping online went from convenience or a luxury to, a mandatory safety type relationship with customers. And so certainly I don't think anyone disputes that people are doing business online. And since that's the case, if there are people who, for example, are blind or have a hearing impairment, there are lawyers now jumping in saying, hey, those people need protections too, because they use technology, they use tools like a wheelchair, they use basically a digital wheelchair to access a website or a mobile app or whatever it may be. And if those websites or those mobile apps aren't set up to be accessible to those technologies, they believe a violation has occurred. The sticky part comes in the sense where, again, because of this opportunity, a lot of times these law firms will just simply join together with, 2 or 3 plaintiffs, and they'll just go and look for as many websites as they can. And so even though their client really wasn't a bona fide customer, had no real intention of ever shopping or purchasing or learning about products at a certain business, they've already filed a lawsuit claiming that they were. And so that is what we're dealing with. The part that makes it, depending on how you look at it, more exciting and more confusing is that, unlike the ADA and related statutes, there's not a lot of regulation to tell someone on the digital side what they're supposed to do. There's a set of guidelines that some of you may have heard of called the WCAG. It stands for Web Content Accessibility Guidelines. Those are helpful and those are detailed, but even if we all agree that those are the standard or the guidelines to follow, which we don't, the law has mixed authority on that. But even if we did agree with that, there's still no agreement in terms of how to measure yourself against it. Do you use automated scanning tools? And if so, which ones? And what's considered a good score and a bad score? How do you manually test a website with a screen reader? And who's right and who's wrong? How many errors is allowed? We don't have a lot of law on that. Some of you may also, those of you of US-based websites may have seen these widgets. There's a whole economy, of course, around this issue now. And there are lots of vendors and lots of companies that provide products that you can basically pop on the website. Those also come with a lot of controversy in terms of whether they're, effective or not, whether or not they actually invite more litigation attention and so forth. And so it's a little bit of the Wild West at the moment. I think ultimately there will be more specific guidelines. Certainly, a lot of people are calling for them. Congress people, state attorney generals, businesses. We've even been part of lobbying the DOJ to get more guidance on this issue. But in the meantime, until we have some of those standards, if you are operating a website in the US, you should pay some attention to whether or not it's accessible or not. We certainly have that, one way or another, kicking and screaming. We had to develop that practice because so many of our clients got targeted. And so we're somewhat unique in the sense that we actually do the audits ourselves. What we do is we mimic the different tools that the plaintiff's bar is using on websites. And then based on that, we're advising a lot of small companies and a lot of big companies that people have heard of on these types of issues. How do you pressure test your website? How do you make sure it stays accessible? And then how do you also sort of keep the attention off yourself from some of these lawyers that are out there? There's about 20 or 30 different law firms that we count that are bringing these cases on a regular basis. And so that's it. And then from the website accessibility, they span out. So they start saying, okay, well, let's look at mobile apps. Does a mobile app work on somebody's phone? And there's nuances with that, but similar. And they say, well, wait a minute, if someone has PDFs on their website, those need to be readable. So that there could be a whole string of lawsuits about that. And then, as Peter mentioned earlier, there's also now video closed captioning, which is somewhat similar. And some of the same firms are bringing those cases. Basically, it's the idea that if you have video content with sound on your website, that you should enable closed captioning. It's actually very easy to do if you are hosting your websites, hosting video clips through something like YouTube or Vimeo, which is what most of our clients do. There's a way to enable closed captioning, but for those businesses who sort of overlook it or just don't think to do it, they may get targeted as well. And so that's kind of the world right now, in 5 minutes or less, what we see on digital accessibility for websites. Obviously, we can answer more questions, and it doesn't just stop at video closed captioning. It goes on and on and on and on. I think as Peter's going to point out for us.
Yeah, no, Nick, I think your point about firms looking for half-baked laws or laws that were written at a different time, but written in a way that are broad enough to arguably apply in the digital ecosystem. We've got the ADA side, but we've also got this emerging wave of litigation in the US, really specifically in California, Pennsylvania, and Florida, who all have very similar statutes. And in California, it's called the California Invasion of Privacy Act. And these are statutes that prohibit electronic eavesdropping without the consent of participants to the communication. So essentially what the California law says is that a company or party A, if you are communicating with party B, you cannot allow a third party to come in and intercept that communication without consent. So what the plaintiff's bar has done is they said, well, when I go onto a website, your website has dozens and dozens of third-party cookies, pixels, tracking technologies, and those cookies and pixels are picking up what I'm doing on the website. It's picking up my IP address, my machine ID, my advertising ID, all the data that's behind our computers and our browsers, and it's tracking what I do on the website by what's called event data. I clicked on this link, I watched this video, I made this purchase. And so the allegation is that company A that owns the website or the mobile application that is allowing party B, the individual, to participate on the website, they are allowing a third party, the third parties that control these tracking technologies, to eavesdrop and pick up the communication of the individual with the website. That's essentially the theory. And these cases are all under that same theory, but what's happening is over the past several years, they've been targeting different practices on websites. So Nick, similar to what you just said about It started off with website accessibility, then it moves into video closed captioning. Now we're talking about PDFs. The same thing is happening under this bucket of statutes. It really started several years ago with a focus on what's known as session replay software. This is third-party software that a lot of websites have that essentially will replay a user's interaction with the website back to the marketing team or others. It's managed by third-party software, but it recreates clicks to show, well, certain customers sit on top of this link too long, and maybe you should change it to a different color. So it's used as a form of analytics. So the argument was, well, these session replay tools are electronic eavesdropping. That percolated its way through the courts, and there were several court decisions that basically said, session replay, that's really just an extension of the business doing their own analytics. These companies are not pulling this data and using it for their own commercial purpose, so it's not really eavesdropping. So the door sort of got shut on that. Plaintiffs bar then moved to chatbots, which is still happening today. And the argument is, well, that chat feature on your website, behind that chat feature is often a third-party software, a widget, a plugin, and they are either managing the chat themselves or they're just providing the infrastructure and the company manages the chat. Well, the argument is, well, that's a third party now recording the communication, and there's cases percolating through the courts arguing that that's just an extension, and the chatbot companies are not really monetizing the data. So the plaintiffs bar said, well, all right, let's find a different angle, and then they just started targeting the metapixel. And the metapixel is pretty ubiquitous, I would say, in the business environment. Many businesses use it. The metapixel is a piece of code that goes onto your website and can be used across the Meta advertising and analytics platform. And the plaintiffs just said, because Meta picks up so much data through that pixel, and because Meta commercializes the data, or that's the allegation, then it's therefore a violation. And those cases are percolating. I was just mentioning to Chloe and others before we jumped on the webinar, we've now got a new theory coming out arguing that these third-party cookies are the equivalent of a pen register, which is what law enforcement use to wiretap phones. And so you need a court order to set these. They're also arguing that the use of third-party payment providers like Stripe or Shopify, that's the equivalent of electronic eavesdropping. So bottom line is they're continuing to get creative under this statute. And I think, Nick, a similar point that you raised, we do not have clean case law yet that shuts the door on any of these theories. I would say, for example, at the federal level, on the US side, we have federal district courts that are essentially the trial court, and then we have the circuit courts. The district courts, we have a split essentially on a number of these cases forming about what defenses work and what defenses don't work. And we have a couple of circuit decisions coming out. Just yesterday, the Ninth Circuit came out with a decision involving Shopify and basically saying that there's no personal jurisdiction for Shopify to be held accountable under the California statute, because just because they offer a service that's offered in multiple jurisdictions to multiple merchants, that doesn't mean they're particularly targeting California with that particular plaintiff. So we're starting to see, I think, courts take a closer look at these claims, but they're going to continue to evolve under this CIPA, which is the acronym, the California Invasion of Privacy Act, this theory. So to Nick's point, if you have a website or mobile application, not only do you have to look closely at accessibility, but you've got to carefully audit and look at the third-party tools you've got on your site and the software development kits, which are unique to mobile applications, and really closely examine and say, are we disclosing these uses? But more importantly, how are we obtaining consent? And Chloe, this picks up on your theme, which consent is the trend in Canada. Consent is now really one of the dividing lines in defending these cases and settling these cases.
Peter, can I ask you a question about that?
Yeah, please.
How closely are the courts looking at the T's and C's, the terms and conditions, the privacy policies of these organizations? Because in the case that Chloe mentioned with Facebook, the Duas case, the court did sort of do a dive into terms and conditions, privacy policies to see whether this consent issue, the box was checked. And in that case, obviously it wasn't. But just for the people listening at home, I'm sure they'd be curious about that.
It's critical. It's a critical point in all of these cases. And in particular, there are 3 touch points on your website that become critical in these defenses. One is the actual cookie disclaimer, the banner itself. So if you don't have a cookie banner on your website and somebody lands on your website, they are automatically sending data to these third parties. So consent becomes a difficult issue on somebody who just lands on your website because they've had no notice, and where's the implied consent? You can have implied consent under these laws. It doesn't have to be express. So that's why that cookie banner becomes pretty important. What do you say to the person in that banner? Is it straightforward? Can somebody understand it? The second thing that courts look at is, in the cookie banner, did you obtain their consent, or was it a notice only? And so what you see right now across the digital ecosystem, no matter what website you're looking at, you do not see a uniform approach to cookies. Everybody's doing it a little bit different. You either see an accept button and nothing else. You'll see an accept and decline button. You'll see necessary only. You'll see opt out of the sale. That decision, what you put as an option, is a very complicated decision now in the US. It used to be, I think, an item that companies didn't really give a lot of thought to. But now how you present that choice and how you give users the ability to execute that choice becomes an important defense component to this litigation. But we're also now seeing plaintiffs sue about that cookie banner and those choices. There's now a wave of lawsuits alleging you presented me with the option accept or reject. I clicked reject, and you were still running third-party cookies on my site. Here's the screenshot. Therefore, it was a misrepresentation. It was false advertising, a false choice. So that cookie banner becomes important, Kelly. Then what the courts look at, well, I accepted or you gave notice. It's also, what are your disclosures in your privacy policy? Did you give the user the ability to click through? Was there a hyperlink? Courts will look at, what was the color of the hyperlink? What was the font size of the hyperlink based on the surrounding text? Because all of it goes into, in the US, the courts will look at this issue as a contract interpretation issue, and they apply state law on contract interpretation. And the state law on contract interpretation says, does the user who you're trying to bind to your terms or to your privacy policy, did the user understand what they were accepting? And so the courts will look at, where was that option presented to the user and how did they accept it? Kelly, to your question on the terms, one thing we see US courts focus on in looking to enforce the terms and conditions is whether it was a click-through agreement or a sign-up agreement. And the distinction between the two is, click-through is where there's a checkbox presented. And before you can proceed, you actually have to take an action, check the box that says, I accept the terms. A sign-up agreement is where it says, by proceeding, you agree to the terms. So it doesn't require an affirmative action. And that may seem like a small distinction, but the courts actually rely on that distinction, and they will usually enforce a click-through agreement because it requires an affirmative act by the person. The sign-up agreement, the courts will still enforce it, but they're going to drill down on, how big was the disclosure? What was the font size? Was it hyperlinked? How sophisticated is the user? Did they actually click it? So all of these, I think, to step back at a 10,000-foot level, all of these risks, NICS, the accessibility risks, these risks, requires careful planning at a strategic level throughout your digital ecosystem, website and application. At any point you are collecting people's data, to say, should we be doing an additional disclosure? Should we be doing a checkbox here? Should we be doing a clear acceptance consent here? And I'll leave you with this, and then Kelly, I think I'd love to hear your thoughts too on the emerging. We're talking about what's in the now, but I think AI is really what's on the horizon. But to leave you with this thought, all of these issues we're talking about, notice, consent, to defend against this litigation. In the US, we also have now a patchwork of 12 states with omnibus data privacy laws. California being the one with California Consumer Privacy Act. We have Colorado, Virginia, Connecticut, Utah, all in effect this year. These laws impose additional requirements on notice, consent, telling somebody you're selling their data. What is a sale? What is sharing? So it just gets back to this bottom line is, don't ignore all of these disclosures on the website, even though they may look small. That one line above the pay now button that says, by continuing with this purchase, you agree to our terms. If that's not hyperlinked, if you don't have a checkbox, you may be basically not protected by your terms. So I think that's the key takeaway for folks with business operations in the US is just really start to look at that with a fine-tooth comb. But Kelly, I want to toss it to you to now, be the futuristic viewpoint. And I think, from the US side, AI is increasingly becoming a litigation risk, but would love to hear what's happening in Canada around AI and where you see the risk landscape heading.
Sure. I will look into my crystal ball and tell you where we're at in terms of our regulatory patchwork here in Canada from an AI perspective. I'm going to look at this from a privacy perspective, mainly as opposed to IP and copyright. I'll just give you a high level overview. Basically, Quebec was first out of the gate, as they often are, with an act representing the protection of personal information in the private sector, which is a mouthful, so we're just calling it the Quebec Act. It took effect in September of this year and imposes obligations on the use of personal information to make decisions about individuals exclusively using automated processing. And the exclusively part is important because these would be decisions where the AI is basically making, for example, decisions on hiring, firing, remuneration of employees. So in those cases, the Quebec Act creates an obligation to advise individuals when their PI is being used to render this decision. And you have to tell the individual at the time, at least no later than the time that the decision is being made. So if you are using exclusively an automated processing system in Quebec to make decisions about individuals, for example, in a hiring context, you would need to disclose that to them at the time that the hiring decision is being made. We've seen this in other privacy statutes, so the right to request information by an individual, and it's the same here, where an individual can request to know the personal information used to render the decision about them, the reasons and principal factors and parameters that led to that decision, and then they have a right to request correction. So we don't have any guidance yet because this law is so new on, whether an organization would have to describe the personal information used to train the AI system. You can imagine how difficult that might be, especially if your organization is hiring the services of a third-party service provider to provide you with the AI system that you're using. And certainly they most likely won't want to disclose any intellectual property of how their AI system works. So this is going to lead to some tricky issues with third-party vendor contracts, we anticipate. But again, it's early days, so we'll have to see how this plays out in Quebec. We, unlike the US, do have federal privacy law here in Canada. So that's where I would go to next with COPITA, and we have a federal regulator, the OPC. But the federal government did table Bill C-27 in September of 2022, and it's called the Digital Charter Implementation Act, and it has two parts, one of which is the Consumer Privacy Protection Act, the CPPA, and the other is the Artificial Intelligence and Data Act. I'm calling it ADA. So I'll start with the CPPA because it does have components of it that touch on AI systems. Right now, Bill C-27 is in committee, so it means it's being debated, and we anticipate it being passed sometime in 2024. The CPPA imposes obligations on organizations using automated decision systems. I love how each of these statutes uses a different term for basically an AI system. But at least with CPPA, we have a definition in the legislation. I won't read it to you, but it basically captures any type of AI system that an organization may be using to make decisions about individuals. So the organization under CPPA will be required to describe generally the use of the AI system to make prediction, recommendations, decisions on individuals that could have a significant impact on them, which again, no guidance yet as to what a significant impact might be. So we will be waiting for further information on that. But I would note that under CPPA, so under the federal legislation, it is broader than the Quebec Act because it does apply to the use of AI systems to assist human decision makers in making these types of decisions. So there is a human element here under the CPPA, which will be captured by the regulation and be a regulated activity, whereas in Quebec, it's exclusively the AI system making the decisions. So that is the CPPA. The other piece of Bill C-27, as I mentioned, is ADA, the Artificial Intelligence and Data Act. And obviously, this is the one that's the most focused on AI and actually caused the most consternation in terms of feedback, negative feedback mainly, when this part of the bill was introduced. But the purpose of ADA is to basically regulate the activity of people involved in the design, development, and use of high impact AI systems. So again, we have another term here, high impact systems, not defined currently in the legislation, which was part of the negative feedback that the feds received on this statute. But the purpose of ADA is to prevent harm to individuals. So that could be psychological harm, physical harm. It's also meant to prevent harm to property, to economic loss. And then another piece of the harm that this act is trying to prevent is what's been in the discourse, biased outputs. So that's where an AI system would differentiate without justification on a prohibited ground of discrimination, which this statute points to those as set out in the Human Rights Act, which many of us are familiar with in the employment context. So that's really the purpose of what ADA is. In terms of what the obligation is, if you are an organization using a high impact system, you have to do an assessment and determine whether your AI system is a high impact system. You have to implement mitigation measures to ensure that none of those negative harms occur. And then you have to monitor the mitigation measures that you've put in place. And there is a recording obligation in the statute, and this is just best practices generally, to make copies of and create documents delineating all of the decisions that are made in implementing your high impact AI system. Finally, there is a requirement under ADA for some sort of public disclosure if you are using a high impact system. So you have to make it publicly available in plain language on a website, how the system is intended to be used and the types of content that it's intended to generate and the decisions that it's making. So that's sort of a high level overview of what ADA does, what it regulates. Further guidance from the government has told us that even once Bill C-27 comes into effect, like I said, that it's expected to be sometime next year, there's going to be a whole consultation period with stakeholders afterwards to determine what the regulations will be for ADA. And the government doesn't expect that to be complete until sometime in 2025. So we're on a very long track here in terms of AI regulation. Last thing I'll say about it, there were amendments that were tabled in October of this year to ADA. I'm told this went off like a bomb with the committees, unexpected. It was meant to sort of facilitate or to explain what a high impact system is. And I won't go through all of the different categories, but it's the sort of decision making that you would expect AI to be used in. Including employment-related decisions, as I mentioned, determining the types of services to be provided to customers and the cost of those services. So if you're using AI in that context, likely a high-impact system that's regulated. Obviously, biometrics information, if you're using that with AI, then it's going to be regulated. Healthcare, emergency services. This one's kind of interesting. So if a court or an administrative body is using an AI system, it's likely high impact, and so then will fall under the regulation. And then, of course, any sort of law enforcement or policing use of AI will fall under regulation. So that's kind of where we're at in Canada. The only other thing I'd highlight is that this law is going to have teeth. So the fines are significant under CPPA, under Bill C-27 generally. We're talking about administrative fines under CPPA of up to 10 million Canadian, which in Canada is a lot of money, 3% of global revenue. And then under ADA, an organization could be liable for an offense of up to 25 million Canadian or 5% of global revenue. So we're into sort of GDPR-like fines and penalties as a result of being offside this regulation. So Peter, I'll throw it back to you because this is usually the part where I start talking about south of the border class actions in AI and the types of lawsuits we expect to trickle upwards.
Yeah, No, that's really, really helpful, Kelly. Thank you for all that context. I think to step back for everybody on the webinar, why are we talking about AI as a risk? AI has been around for a long time, for decades, as a concept. I mean, if we use Westlaw to run a search, that's artificial intelligence. It's any type of computer program that can generate a result that augments human intelligence. So the concept's been around for a while, but as of last November, this new form of AI called generative AI came on the scene. And that's what has disrupted the entire digital ecosystem, because generative AI is a form of artificial intelligence that can generate text, images, video at a remarkable rate and mimic oftentimes human interaction and capability. So that's what's got regulators' attention in the US and Kelly in Canada and globally. And so there's a global debate happening right now as to how can we regulate a technology that is moving so rapidly. And the challenge around AI is that the promise of the technology is that it continually improves indefinitely. Therefore, how do you regulate a technology that will eventually become self-regulated and eclipse human oversight? And that's the challenge that everyone's wrestling with. On the US side, we have discussions happening at the federal and state level, and we have litigation now percolating. And that's because generative AI can introduce a lot of legal issues. For example, if you are using a generative AI tool to generate images, and you type into this tool, create for me a picture of Nick Pujji riding a horse into the sunset, which I do have as my screensaver on my laptop. It pulls pictures of Nick, of horses, of sunsets to create a new image. So there are lawsuits now alleging that those tools are actually scraping copywritten material to create this new image. And so there's litigation threat, there's privacy risk, there's transparency risk, because you don't quite know how these tools actually generate the material. So at the federal level in the US, we don't have a federal AI bill. We have several bipartisan proposals pending. The White House on October 30th issued a massive executive order directing all federal agencies to develop responsible AI policies, directing certain private industry to report on AI safety. We have diplomatic discussions happening at the nation state level on developing safety protocols. But at the risk in the digital ecosystem level, we have states really leading the charge in the US, not unlike in the privacy space, states leading the effort to regulate the use of AI. So just 2 days ago, the California Consumer Privacy Protection Agency released draft regulations regulating automated decision-making technology that processes personal information. So Kelly, very similar to what you guys are looking at in Canada. And essentially these regulations say, if you are using any level of AI to process somebody's personal information in California for certain decision-making activities, you have to not only provide notice to that individual, you need to give them the right to opt out of that activity. And the notice has to be pretty descriptive about what's the logic behind the tool? What are the key parameters being used in the tool? So we're starting to see state regulators get very granular. And I think if we're looking at what's the future risk in the US, that area in terms of regulatory oversight on using AI in employment, using people's personal information, healthcare, making financial decisions, that's what the state and local folks are really zeroed in on, those use cases. At the same time, though, because we're the US and we are, I forgot what you said, Nick, we're litigious, we've got opportunism, there are a wave of lawsuits right now around the use of AI. And so copyright lawsuits are pretty prevalent. They've got a lot of headlines. Sarah Silverman, for example, is leading a lawsuit against OpenAI, and Meta, the author of the Game of Thrones series, sued OpenAI, alleging that it basically scraped. If you type into ChatGPT, write me a story about middle-aged conflict, it's pulling from Game of Thrones copywritten material. So copyright lawsuits are percolating. Issues of IP protection are becoming an issue. We have a trademark office decision saying that material generated by AI is not protected by trademark. You have to have a human element involved. So we're starting to see more law develop in that space. Where I think we're heading on the US side, on the plaintiff side, and I don't want to give the plaintiff's bar any unique ideas, but as businesses start to increasingly use AI in the consumer-facing environment, chats on the website, interaction on call-in centers. There are call-in centers now that use AI to mask the person on the other end of the call center. If they're from India, the AI will actually make them sound like they're from the Midwest. There's AI that's being used across the ecosystem in consumer interactions, and it's only getting more prevalent with these tools. So I think we're going to see an increase in lawsuits around unfair business practices, deceptive practices. You're not telling me I'm engaging with artificial intelligence. We just saw over the past few days, somebody released Johnny Cash singing Taylor Swift and releasing all of these different songs that Johnny Cash can now sing. So you can see where the public can be deceived. There's going to be manipulation. So wherever that occurs, there's going to be consumer protection advocates filing lawsuits. So I think if we're thinking about trends in the US on the AI side, to boil it down, we're going to continue to have federal developments. We may even have a federal AI bill, a federal AI law. I'm not holding my breath that that's going to occur before our next presidential election next year, but that's still occurring. We're going to see more activity at the state level, California being a leader. New York City has a law on the books that regulates use of AI in employment decision-making. Colorado's looking at one, has a law on the books around insurance decision-making. We're going to continue to see that regulatory focus. And then I do think we're going to see the plaintiffs bar pick up on this as the next thread. ADA accessibility, we've got privacy and third-party tracking. As AI becomes more prevalent in the background of all of our digital experiences, they're inevitably going to focus on the use of that. So my key takeaway, and then Kelly, Nick, and Chloe, I want to wrap up with your all key takeaways for folks on the webinar. My key takeaway on the AI side is put in place AI governance, AI policies, AI structures to mitigate the risk. Identify your use of AI, mitigate it with vendors, be clear on the transparency side, very much following the principles that we have on the privacy side, but it's a technology you really can't ignore. Nick, I'll toss it to you for your key takeaway as we wrap up.
Yeah, to reiterate my parts, if you keep it simple, if you are operating a website that is US facing or does business with US based customers, even if you're not selling anything on that website or doing financial transactions, it is important to have someone take a look at your website accessibility issues, run audits and test and have a plan in place. Because given the trend and the volume at which these cases are being filed, it really is a question of when, not if, you'll be targeted, because you've got multiple law firms looking for new websites and targets on a daily basis.
Kelly, I'll toss it to you for your lightning round quick takeaway.
Sure. I would just emphasize again the importance of record keeping in all of this, especially for new technologies like AI. These regulators are going to have audit abilities. If you get into a litigation fight, you'll have disclosure obligations, and having those contemporaneous records showing the decision-making process as you went along will be very helpful in a due diligence defense.
Great. And Chloe?
I would have two takeaways. One is about employees and making sure that they are properly trained and only given access to the information they need to perform their jobs, and that if you're looking to monetize personal information that you are collecting, to have thought through the consent and what your arguments would be if there was a complaint.
Well, thank you to the three of you. I always enjoy catching up with you, and hopefully we can do it again on another cross-border series. And to our attendees, we hope you found the session to be valuable. Just to recap, the recording of the presentation will be sent out post-event in a post-event email. So on behalf of Nick, Chloe, and Kelly, thank you very much for attending, and have a great rest of your day.